So how do slip and fall cases actually work? In this scenario, a person is usually walking somewhere, they slip, they fall, they hurt themselves, they want to bring a claim. So what's the actual process? Well, slip and fall cases can be more complex than a typical rear end car collision because just because a person slipped and fell on someone else's property does not mean the owner of the property is automatically responsible for their injuries. There needs to be some sort of evidence that the property owner did something wrong. So property owners have a duty to use reasonable care to fix an unsafe condition. For example, a business has to provide warnings if they just mop the floors and it's really wet. If you're in a grocery where there's things falling on the floor all the time, there may be some responsibility to have the staff go through and sweep the areas every certain amount of time to make sure things are safe. A landlord might have a responsibility to cover up holes in asphalt parking lots, things like that. So if somebody does something wrong and someone else is injured because of it, they may be able to bring a slip and fall claim. If you just simply slip and fall and there's nothing apparent that the landowner did wrong, you probably won't have a claim. So you have an injured person. They fell, they believe their injury was due to the negligence of the landowner, their failure to fix an unsafe condition. So how does this claim actually work? Well, there's a couple ways you can go. If it's a small claim, minor injuries, you may want to contact the landowner yourself, not retain a lawyer, and try to negotiate a settlement. A lot of times the landowners or their insurance carriers will resist payments on slip and fall cases unless it's pretty obvious. So that way may work or may not work. If you do have a more significant case, you're probably easy for me to say, you're probably going to want to contact a lawyer and have the lawyer help you with the process. So a slip and fall case is another kind of a personal injury case. So the main two ingredients of personal injury cases don't really change. The first ingredient is you need to show liability. You need to show that the landowner did something wrong and is liable for your injuries. So in order to do that, you're going to want to document what happened. If you're in a grocery store and there was a banana peel on the floor for a long time, you didn't see it and slipped and fell on it, you're going to want to take pictures of where you fell. You're going to want to take pictures of the banana peel. You're going to want to look around and see if you can see video cameras anywhere, because you're going to want to get that video footage. If there's somebody that was a witness there, says, oh yeah, that banana peel was there when I came into the store 20 minutes ago and it's still there, you're going to want to have that information because you want to use it to build your case to show the landowner is liable. The landowner did not do what a reasonable landowner should have done, and because of that, the landowner would be responsible for your injuries. The second component you need to show in this and all personal injury cases is that you're actually damaged. And again, your damages are going to be things like medical bills, lost work, pain and suffering, different costs. So you want to document all of that. When you go to see physicians, you want to get the reports saying, hey, look, this person has this injury, and you tell the doctors why you have the injury, that you had a slip and fall and that's why you hit your head or whatever it was, and the doctor's probably going to put that into their report if the doctor believes it may be related. So not only do you want your doctor reports, but you also want to have all of your doctor bills. So what happens is this information needs to go to the insurance carrier for the landowner that's presumably responsible for your injuries. So once the landowner gets through part one and goes, oh man, look, the people we insured really screwed up. A jury's probably going to find liability here, probably going to find the company we insure is responsible. So we're going to need to pay. So the damages side is what they're going to need in order to decide how big a check to write. So it's very important for you to give them everything they need. Don't hide anything. Give them your medical records that are related to the accident that happened, the slip and fall. Now, what are they going to ask you? They're probably going to ask you, hey, we want to see your medical records from 5 years back, 10 years back, something like that, because we think that, hey, you know what, you're concussion was not really from you falling down. You came into the store with a concussion and it didn't happen because you slipped on the banana peel. Well, are they entitled to get that information? Yeah, they probably are because it's part of their due diligence. Now, if they want to get into your medical records and see that you had a butt lift, but your claims are related to your head, that's probably not related, and they're probably not going to be able to get that information unless you voluntarily give it to them, and you really don't need to voluntarily give them that. So they've got the information regarding liability. Now they've got the information regarding damages. They're going to use their internal meetings, numbers, calculators, whatever it is, and they're going to come up with a value range based on the information you've provided them and based on what these cases generally resolve for. And they're probably going to make you an offer, and it's going to be a range that's low to high, and your first offer is almost guaranteed to be the low end. So don't take it right away. The next step is generally negotiations to try to come to some number that works for you and it works for them. And as I've said before, be careful about early settlements, especially small early settlements, because when you agree to sign the release in exchange for a check, you're releasing all your claims, generally known claims and unknown claims. So if you get your check and everything's happy, but the next week you go to the doctor and they say, oh, look, you know what, we've detected you have traumatic brain injury from this. We have to do a lot more studies. We have to do a lot more treatment. You can't go back and reopen your claim and say, hey, look, I need more money now because of this, that, and the other. And the insurance company will say, no, you've already released all of your claims, known and unknown. So we're done. You can go to your own medical provider and do whatever you want to, but we are not responsible for any of that. So be careful with early small settlements. Now, if your case doesn't settle early on, you may need to file a lawsuit. And depending on your jurisdiction, you only have a certain amount of time to file your lawsuit. I'm here in Nevada. The statute of limitations for a personal injury claim is 2 years. That means you need to file your claim within 2 years or else your claim is lost. So if you're unable to resolve the case early, in order to start the lawsuit process, you file something called a complaint, and it shows your name at the top, who you were suing, and that'll be the property owner. Although that can be a little challenging to figure out. If you're going to a property and let's say it's a guitar store and you go to the guitar store, but you trip in a hole in the parking lot, well, you might think, oh, I'm going to sue the guitar store, and that might be the right thing to do because it's their parking lot and because they didn't fix this hole that was dangerous, you were injured. However, the guitar store might be leasing the property from a landlord. The landlord might be responsible for what's called the common area, which would be the parking lot. So maybe the landlord is going to be responsible instead or also. So you definitely need to do your due diligence to figure out who it is you're supposed to sue. So anyway, you file a lawsuit and you bring it to the court, and the court files it, stamps it, and then you need to hire a process server to go and actually serve the lawsuit on the store, the landlord, the person, whoever it is you're suing. And once they've been served, they have a certain amount of time, maybe 20 or 30 days, depending on your jurisdiction, to file what's called an answer. And their answer is responding to your complaint. And then you're off to the races with the litigation process. The first thing that happens is going to be discovery. And so each side's going to send each other written questions they have to answer. Each side's probably going to retain experts if this is a larger claim that requires experts. And then each side's going to have to do depositions. If you are bringing the claim, there's about 100% chance that you're going to have your deposition taken by the other side. And that's a very important part of the claim because that's when the other side gets to see what kind of a person you are. And if you're a great, likable person, juries like to give people they like lots of money. And if you're a horrible, horrible person, a jury's going to hate. Well, juries tend not to give horrible people that much money. So it's important for the other side to take your deposition so they can get an idea of what kind of person a jury will think you are. After that happens, there's probably going to be a mediation or both sides meet with a mediator in an office and try to negotiate a settlement again. If that fails, you're off to trial. Trials are complex. They somewhat are costly. And so that's why most cases settle without going to trial. But if it does go to trial and you're bringing the claim, you're going to have to be there every day. from picking the jury, opening statements, witnesses, closing statements. It's a long and somewhat complex process. It's going to take your lawyers a lot of time and frustration. So that's why their contingency fee may bump up from before trial to once trial triggers. For instance, if you have a contingency fee with your lawyer that says, hey, I get 33% of the recovery before trial, but if this goes to trial, it's going to bump up to 40%, maybe even 50%. That's why, because trials are hard. They take a lot of time and effort and work and can be frustrating at times, or maybe even a little fun at times. So anyway, a trial happens, a jury comes back with a verdict, and if you are the winner, then not only do you get the verdict, but your lawyers can also apply for fees and costs afterwards to try to get a little bit of the costs that were put into the case back to you. And just to be clear, the money's not actually back to you. What happens is at the end of the day, you're going to get a check for, whatever the verdict is, plus costs and fees and things like that. The lawyer is going to take the 30 or 40 or whatever percent off the top. And then after that, the fees and costs are paid out of it. Any medical bills that are outstanding are paid out of that. And then the rest of it goes to you. And ideally, the lawyer will never take more than you get as well. So that's a quick overview of how a slip and fall happens. These are, like I said, a little more complex than a typical rear-end car accident. So if you've got some significant injuries and a bit of a complex issue, you're probably going to be best off hiring a good lawyer, or at least talking to a couple of them to see what information they can provide you and maybe give you a little advice of which direction to go.